our Becker Center guest lecture this afternoon. Thank you all so much for being here. I know many of you traveled, some of you from Columbus. Thank you so much to our friends who came from Columbus and Cleveland and the Akron community. Thank you to the faculty members that are here this afternoon. It's so good to see all of you. Within professional responsibility circles, there is one Paula. There is a Paula inside of the APA, everybody knows, inside the National Organization of Bar Council. When you say Paula, everybody knows who you're talking about. And I should introduce myself. I'm Heather Zerkin, the interim director of the Miller Becker Center. And no one knows me. And when I became the interim director of the center, the first order of business was to find a speaker to come, somebody to do the guest lecture for this fall. And I knew who I wanted. I wanted Paula, who's like Cher, just one thing. But I didn't know how I was going to get her here. I queued up an email, but you know, emails can get buried, they get ignored. So I queued up my email, but I wanted to call the State Bar of Georgia and try to get a message to her so that she could know how much I wanted her to come to Akron. And I was ready to engage with her and just hope that somehow a message would get to her. And I Googled the number for the State Bar of Georgia, large organization, it's a mandatory bar, 55,000 members. Who cares if somebody from Ohio was calling? But I called the office of the general counsel and I hear Paul Frederick. And there was a long pause because I hadn't prepared for what would happen if she I would imagine that she would pick up the phone. And so I explained who I was very quickly and what I wanted, and she laughed and said, I think she could probably hear the desperation in my voice. And so the rest is history because she is here. And I am so excited. I'm so excited for all of you to kind of get to know her a little bit and to hear what she has to share this afternoon. So let me share just a minute about Paula. She is the general counsel for the State Bar of Georgia. She's been with the Office of General Counsel for 35 years. At the beginning, she started out as Deputy General Counsel before becoming General Counsel. She's a graduate of Vanderbilt University School of Law and also Duke University. She's a past president of the Atlanta Bar Association and the Georgia Association of Black Women Attorneys. She's an active member of the American Bar Association, where she is the chair of the Center for Professional Responsibility, and she's a past chair of the ABA Standing Committee on Ethics and Professional Responsibility. And I'm so delighted that she's with us. Would you all help me welcome Paula Frederick?
Thank you for that ridiculously kind introduction. I am not that hard to get on the phone. My email tag, my signature thing has my direct line and my cell phone number on it. And so every respondent in the state, not to mention the people who have filed grievances against lawyers, does that same thing, calls and I think expects to get a voicemail, and they're a little bit taken aback when they actually get me on the phone, which is good because it took me a minute to sort of get the upper hand and get the phone. Anyway, don't call if you don't expect to pick up the phone. Thank you for having me. I am delighted to be here. I had never been to Akron before. And as Heather, I think, found out, don't invite me anywhere if you don't want me to show up. Never send me that pro forma invite because I'll go just about anywhere. And I've had such a nice time. Heather has done a great job of making me feel at home. She fed me well last night, and here I am working for myself. What I would like to do with the time here today is just to give you a little bit of information about amendments which the American Bar Association is proposing to Model Rule 5.5, which is the one that deals with unlicensed practice of law and multi-jurisdictional practice of law. And as I do every time I talk about model rules, the ABA rules, and what the ABA is planning to do, I beg you to keep in mind that the ABA can only enact a set of model rules. They can't force anybody to adopt them. The rules would, if the ABA approves them, would have to be adopted by Ohio, I guess by its Supreme Court. And that's the precedent going to be coming effective on those of you, I'm assuming you all are Ohio lawyers. And so to some extent, doesn't matter what the ADA does, you can take it or leave it. But I think my involvement in the ADA is really because I believe that it is at the forefront of these issues. It's the leader in thinking about these issues. And this one's going to be a big one because the proposal right now is for, they hate it when you call it this, but I'm going to call it this because I like this term. It's a driver's license model for licensing lawyers. So that if you have a license in one state, you can drive anywhere with it. And you don't have to go through separate bar exams for separate U.S. jurisdictions. So that, in a nutshell, is the proposal. I am going to just start by acknowledging that half of what I'm talking about has been listed from conversations with these folks. David Majrak is a California lawyer who is part of the task force with the ADA that's looking at these issues. April McMurray is a regulation lawyer in Colorado with their Office of Disciplinary Enforcement. I've been on 2 panels with them for some reason in various places around the country talking about these issues and really appreciate their insight, and so I have to acknowledge that. The Association for Professional Responsibility Lawyers really was the catalyst for this whole conversation coming out. They are an organization of lawyers who mostly represent lawyers in disciplinary cases. So they are my opposing counsel when we have disciplinary cases. But they're a good, thoughtful group of lawyers who did a lot of work towards prodding the ADA into this. A great organization though they may be, they don't have the ability to change the model rules of professional conduct. And so what they did is a lot of the work that persuaded the ADA that this was something that needed to happen. So, how do we get here? Before we talk about what the rule is and how and why the rule ought to change, it's helpful to do a little bit of a look back. And to start that, I think it's interesting to note every U.S. jurisdiction has a different definition of what the practice of law is. It's defined in state codes for the most part. And it's one of those situations where you start trying to define something, you're immediately using the word you're trying to define in the definition, which is supposedly a no-no. And you finally just give up and say, I know it when I see it or whatever. But in Georgia, for instance, the definition of the practice of law is appearing in court on behalf of other people, getting paid to do lawyer stuff. And the money really is part of our definition. I think you can almost do a lot of things for free if you wanted and not be accused of the unlicensed practice. But the catch-all at the end of our statute says something like thinking about the law. So how could that be? That just sort of thinking about the law and applying your thoughts to somebody's specific situation is how we define the practice of law. So the definitions are broad, and they are vague, and they are all different. And that is just not a helpful thing for lawyers. When a lawyer wants some guidance, you really do have to look at the law of every single jurisdiction before you know whether the conduct that you're proposing is okay. And that's just impractical and really kind of unfair for people who are trying to do the right thing. I talked to a lawyer on our ethics hotline a couple of days ago who was headed to some other jurisdiction to do something, and he calls me and says, I know you guys have my Georgia license, and I don't want to get in trouble, so I wanted to call and make sure that I could do this thing in Arkansas. And I had to come up, nice talking to you, you had to call Arkansas. And I don't know who there you should speak to or how to get the information or whether they can operate a lawyer hotline to make it easy for you to get the information. So good luck. But that's the way that it works right now, and it isn't particularly easy. So how do we get here? And this is not, I am not a lawyer historian by any means. So I'm going to just broadly talk to you about how lawyers have been licensed and who decides whether what they're doing is okay or not. start with from the time the country was created. In the 1700s, there were no law schools initially. We really did kind of borrow the whole way that we do things from Great Britain. And so since they had this common law concept that said that the judiciary has the inherent power to regulate everything related to the professions, that's the way we wrote it. So we looked to the judges, the judiciary, to say what somebody in the U.S. colonies could do, who could practice law, and who couldn't. So it really started with nothing more than a determination of character and fitness by a judge or another lawyer. Is this person qualified to practice law? And there are clearly some flaws with that. If you know the judge and the lawyer, you're probably more likely to be determined to be fit than if you don't. And so in the earliest times, it was only men, it was only white men. And a lot of times it was white men who were related to the white men who were administering the character and fitness test. But it was as simple as that. If you were being fit, if you had the requisite moral character, and some other lawyer thought it would be okay for you to practice law, you were allowed to practice before a court. The court would give you permission to practice before it. The next thing that happened, though, is that law schools came about. And I think the reason, just from my reading, the reason that education became a real factor in all of this is because it seemed more prestigious than other ways of becoming a lawyer. I mean, under this character and fitness model, people would apprentice, and they just go work for a lawyer. They clerk for a lawyer. It was boring. They were doing menial tasks. They weren't, depending on who you were working with, you might learn something, you might not. Going to school in order to gain some information about the law just seems like a more prestigious way of becoming a lawyer. You still have to go through that character and fitness stuff, but education became an accepted way of learning what you needed to know to become a lawyer. And the law was getting more complicated, so education was also necessary as the country developed and the law developed and commerce developed. So finally, this idea of an examination came around. And it was really more towards the end of the 1800s, beginning of the 1900s, that jurisdictions started adopting the idea that we should do this whole thing and require people to be examined and pass a test before they become lawyers. So in 1850, there were only 15 law schools in the country. By 1920, there were 146. And what you saw next is this upstart organization, the American Bar Association, coming in and expressing its views about licensure and admission of lawyers. The ABA in the 1920s commissioned a report that in 1921 made recommendations for the first time about what you ought to do to become a lawyer. And that's where this whole idea of 3 years of school, and initially it was 2 years of actual training and reading the law, and then 1 year as sort of an apprenticeship kind of thing. This idea of then you have to pass, well, then you have to become certified as morally fit to undertake the responsibilities of a lawyer, and you have to pass some sort of examination. And, it's probably no coincidence that the ABA sort of took charge of all three of those things in issuing model rules and examples of ways to do things, and became the arbiter that it still is in a lot of ways about certifying law schools, accrediting them, model rules for things like determining character and fitness and how that ought to be done. And the bar exam, I guess, isn't done by the ABA, but they are the group that really pushed the idea that you need these hurdles for people to go through. Now, the stated reason for all of this is protection of the public. That we protect the public by keeping out of the profession people who don't have the necessary knowledge, the necessary experience, or the necessary moral character to be providing legal advice to other people, holding their money, that kind of thing. And that, you know, I should have mentioned that earlier because that's the reason that this entire system exists, supposedly, is protection of the public. And as we talk about whether it ought to be opened up to this driver's license model of multi-jurisdictional practice, I think that's the reason that it either should or shouldn't be. And that's the rationale that we have to keep in mind. Why are we talking about this? And is it something that we can do and still protect the public? Is it helpful to the public or is it not helpful to the public? So, in the 20s, the ADA sort of cemented its role as a leader in this area and sort of set these standards that they were hoping that everybody would comply with. And as a result, in the model rules of professional conduct, you saw a provision, and I can't remember exactly when this unauthorized practice of law provision first came into being, but there wasn't a provision about unlicensed practice of law in the initial canons of ethics, the sort of 1908 version. By the 50s and 60s, there had been this whole move, largely led by the lawyers, to keep people who were not lawyers from doing things related to practicing law. And, you know, where there's harm, I think that's easily justified, but where there's not harm, you know, who knows? Should it be something that we automatically say ought to be prohibited, or should it be something that we try out? And I'll talk a bit more about that later. So this first provision in the Model Rules of Professional Conduct provided that a lawyer shall not practice in a jurisdiction where doing so violates the regulations of the profession in that jurisdiction. That means you look to the unlicensed practice statute to see what it says and make sure that what you are doing doesn't violate the rules in that jurisdiction. And maybe other rules that are rules of court in a particular jurisdiction, but typically we're looking at the UPL. Part B, you can't assist somebody who isn't a lawyer in doing something that constitutes the unlicensed practice of law. We say unlicensed now, this is we say unauthorized practice of law. So the rule itself really is forcing you to look at geography. You know, where is this lawyer licensed? What does it mean to practice in a jurisdiction? Then you go back to the UPL statute and get that vague and broad definition about what UPL was. But one of the things that I truly hadn't thought about before I went to work at the bar is this whole concept that lawyers can engage in UPL. And I think it's not a natural concept for me because I can sit in Georgia and talk about the law of Ohio all I want. And so what difference does it make where I am visiting? But it makes a lot of difference under these statutes. So just for a minute to talk about the kinds of things that my office sees or saw back when this rule was in effect. This is pre-2002. We got a lot of complaints from opposing counsel in a case. And actually, Joe, you talked about one of these last night, where you're sitting in your office in Georgia and you get a call from a client who says, I just got a demand letter from some guy in California who's telling me that something I did wasn't right and he's threatening to sue me. It's like, let me look it up. If he's not a member of the state bar of Georgia, what's he doing writing you sitting here in Georgia? And so we would get complaints about lawyers engaging in unlicensed practice of law when they're doing something from out of state that interprets the law of a different state, or when they come here and do something that's not authorized by law. For instance, should it be UPL when a lawyer comes to town to take depositions for a case that they're working on at home? Or should it be UPL when they come in to interview witnesses and they don't have anything filed? There's no opportunity for admission for refuge. But those are the kinds of things that we used to see. And the only way that this rule could be enforced was by the jurisdiction that holds the lawyer's license. So if a Georgia lawyer has screwed up in Ohio, Ohio can say, well, we're not going to let you practice here anymore in court. I mean, we know about it. But Ohio can't suspend, disbar, or reprimand the lawyer. And so what they do is send a referral back to the lawyer's home jurisdiction, say this lawyer came here, they screwed up a bunch of stuff, and we want you, Georgia Bar, to discipline this person. As you might tell from the tone of my voice, the enforcement sometimes of that is sporadic, it's iffy. It just kind of depends on what the conduct is. So before 2002, we would routinely get referrals like that from the places that didn't want Georgia lawyers encroaching. Say Florida, where they have a whole bunch of lawyers, where all my Georgia lawyers want to retire to their beach house, and Florida's just like, we got enough, we don't need you guys, thank you so much, stay home, go home. So they send a referral and say, you've got a lawyer down here screwing up, sanction them. And depending on what it is, maybe we would, maybe we wouldn't. The ones that seem unfair, frankly, are the ones where there's no way for the lawyer to do it right. And yet it seems like nobody's been harmed. So we've got lawyers stealing money that we prefer to spend our time on. Like, actually a referral from North Carolina for a lawyer appearing before a school board tribunal for a relative or somebody who had gotten in trouble at work, and the lawyer's in one of these border towns and goes in. There's no opportunity for pro bono admission. There's no harm to the person. The client knows where the lawyer's licensed and wants to do it, and yet you're supposed to sanction the lawyer. A lot of jurisdictions did and do sanction lawyers for that exact thing, and it just sort of depends, I think, on where you are and how busy your regulators are as to whether that's the kind of thing that they want to spend their time. But the case that really got everybody's attention was this beer grower case from 1998. And I remember just what a shockwave that sent through offices like mine, where we've been very casual about enforcing some other jurisdiction's rules. Like I said, sometimes we did, sometimes we didn't. So I want to tell you a little bit about this case because I do think it really was the catalyst for changes to the model rule and really ultimately for the kinds of changes that we're talking about today. It was a case that wasn't in court. It was an arbitration, I think. And this New York lawyer was was helping a client with a matter in California. And the matter settled before it even got into court. So the New York lawyer never had the opportunity to be admitted pro hoc jail, never was before a court, but was negotiating with whoever it is that the client had a dispute with. They resolved the dispute. The client later sues the law firm for malpractice because they decided the settlement was not as good as it should have been. So they sued for malpractice. The beer grower firm counterclaimed for payment of attorney's fees. They hadn't been paid. So when they counterclaimed for payment of attorney's fees, the California court says, well, you're not entitled to attorney's fees because the fact that you were here at all violated our unlicensed practice of law statute. So not only are you not entitled to attorney's fees, you've committed a misdemeanor. So they issued this order that got affirmed on appeal, or maybe, I can't remember whether it was affirmed or reversed on appeal, but that was the ultimate finding, was that you aren't entitled to anything because you should have been here in the first place doing this. And the lawyers sort of threw up their hands saying this model rule and statutes don't apply to lawyers from other jurisdictions. The California court said, yes, they do. And it was sort of the highest level court where we'd ever seen a ruling that definitive about what lawyers should and shouldn't be doing in jurisdictions that aren't their own. I think, it just seemed particularly unfair because there wasn't any process by which they could have been admitted. This is an arbitration, it's nothing that is pro hoc admission allowed or required or necessary or whatever. And so it just seemed bizarre. So everybody kind of woke up, and as the ABA does, the ABA decided, well, we gotta get involved here and figure out, is that what we really want Rule 5.5 to do and to meet? And they convened a commission that spent a couple of years just taking testimony from people talking about this issue. And all the obvious problems came out during that process. You know, people use the telephone to call across state lines and to opine on the law of other jurisdictions. Most of us think that's okay if we're physically sitting in our home jurisdiction. Why shouldn't it be okay if we happen to be in Florida? I mean, the state bar of Georgia meets in Florida all the time for its annual meeting. If I am sitting there and working on my Georgia cases, am I violating the unlicensed practice of law statute? So we started thinking about all of these things that were wrong with 5.5. And in 2002, so just a few years later, the ABA revised the rule, and the revision passed the House of Delegates and is now the model rule. So the current model rule is these next few slides that I just sort of want to talk about. The current model rule, for some, with minor deviations, has been approved in 45 jurisdictions. There are a few jurisdictions that have not approved it, but by and large, most have. And this first part is really the old A and B combined kind of. Just says you can't practice law in a jurisdiction in violation of the regulation of the profession in that jurisdiction, and you cannot assist somebody else in doing it. Before I lose that, assist another person in doing a part of it, let me give you an example of that. That's the most common example, only slightly relevant for today's conversation. The main thing that we see there is people who are suspended for disbarment practice, lawyers who are suspended for disbarment, who want to continue to practice, find a buddy and say, let me come help you in your law office. Nobody has to know or whatever. And if we used to have a rule that said if you were suspended or disbarred, you could not maintain a presence in a law office. A court found that unconstitutional, so we took it out of our rules. But I still think it was protective of the public because we've got jurisdictions in my state, just small town type jurisdictions, where everybody knows and everybody loves the lawyer who is ultimately disbarred, and people just keep wanting that person. And so it's pretty easy for them to keep practicing, although unfathomable to me. And so we say it's a violation for you, lawyer who is facilitating that, to allow that to happen. And that is still in the rules and still a violation of the rules, and frankly, still something that we see now. Second part of the rule, if you're not admitted to practice in this jurisdiction, unless there's some other exception, you can't establish an office or a systematic and continuous presence for the practice of law. So I at least use the language about establishing an office to be you can't hang out, you can't have a brick and mortar space from which you practice law if you are not admitted to practice in the jurisdiction. And I think most people would read that as just no office with your name on the door called attorney at law. Here in Ohio, where I am not licensed. The language about a systematic and continuous presence is a little bit less obvious, and courts have interpreted it differently. There is a comment to the rule that says that you can establish a systematic and continuous presence even though you're not physically present. So it can be done virtually. And, that's one area that still causes confusion for folks. Is this a systematic and continuous presence? I came in for one case, but it's lasted forever. And I still don't have the opportunity to be admitted pro hoc because it's an arbitration or something like that. So part C, if you're not admitted, you can't hold out to the public or otherwise represent that you are admitted to practice in the jurisdiction. And that can be a client asking you, that can be, once again, the shingle on the door. The rules also point out that you can be holding out fines related to advertising. If you advertise that you're available to take cases in a jurisdiction, that's considered holding out for purposes of the rule. So, you know, once again, as we try to better define and give lawyers better guidance, we come up with new terms that are just as confusing as the old terms somehow. And that may be where we are now. I don't know. I think this is definitely better than the last rule. But the exceptions to the rule have 4 circumstances where temporary practice is okay. And we're still talking temporary practice. We're not talking any kind of permanent ability to practice in another jurisdiction. But on a temporary basis, you can undertake a matter if you have active participation from a lawyer who is engaged in the jurisdiction. And for my purposes, typically what that means is that if there are pleadings, this person's on the pleadings. If there's, you know, they know the client, they've met with the client too. It's like the rule that requires co-counsel if you're sharing a fee with somebody. It can't just be a referral fee, it has to be based on some work that you've done. I think here too, it has to be based on some work that the other lawyer has done. It can't just serve as a front for a lawyer from another jurisdiction who wants to practice law. The second one, you can do work on a temporary basis in a tribunal where you expect to be authorized to appear. And so that's the work that you do before you file a case and have the opportunity to be admitted for a check. If you need to interview witnesses, if you need to review documents, if you need to negotiate with somebody in a different jurisdiction, but if the suit's filed, you're going to be admitted pro hac vice, it's just not available to you yet, you can do that. If the matter arises from alternative dispute proceedings in your home jurisdiction, you can handle it because there's no way to get authorized otherwise. Some jurisdictions interpret 3 and 4 here as requiring that the client be an existing client. In other words, you can't get a brand new client to handle an ADR matter for in a different state. My state doesn't interpret it that way, but I think we would have to see, you know, the ADR proceedings in your home jurisdiction, at least things have to have started out in your home jurisdiction eventually. And the same for number 4, arise out of or reasonably related to your home practice. Does that mean it has to be an existing client at home? Or could I come to Ohio and find a client here and act like that somehow had some sort of basis in my practice back in Georgia because it's an area of the law that I'm familiar with? I think it really does have to either be a previous client who has some connection to your home jurisdiction in order to pass muster under number 4. But number 4 really is there to help transactional lawyers because in having all these conversations, you realize they never have the opportunity to be admitted for life. And they're not going to be before a judge who says, okay, you know, I'm fine with letting you into practice. So we needed some language that was helpful to lawyers who negotiate contracts, which, you know, can be multi-jurisdictional pretty routinely. And if it is arising out of or reasonably related to a home practice, then you're good under this current rule. The final part of the rule includes the 2 areas where it's okay to have an ongoing practice in a jurisdiction where you are not licensed. And one is the in-house counsel provision, that D1, if the services are provided during employer. The rationale for that rule is that a company, an entity, who has in-house counsel is not somebody who you'd be worried about in terms of protection of the public. They can protect themselves, they can fire the lawyer, they're probably fairly sophisticated, and we don't have the same concerns that we have about unleashing an untrained or possibly unethical lawyer on the whole rest of the world because, you know, it's in-house counsel. The company can handle things themselves. And the other exception is the federal exemption. If the services are authorized by federal law or other law or rule, then you can do what needs to be done. And so I think every jurisdiction has lawyers who are licensed somewhere else who practice only in the area, and only in some federal law. We've got immigration lawyers in Georgia who do that. And I think the one concern that people have is that a lot of times it's hard to confine the practice to whatever one area is. So if you're doing immigration, good, you can rely on the federal law and do your immigration cases, but many times there'll be an impact on family law. If somebody in an immigration law case is getting a divorce, there might be implications there. And so you're needing to know about bankruptcy or family law, or bankruptcy is federal, that's not a good example, but family law for purposes of the federal matter. And so while we do not spend a whole lot of time worrying about people who say they only practice federal law, I think there's probably ample opportunity for those lawyers to opine on the law of the jurisdiction in the practicing of the federal law. But I don't think we've seen problems from that. I'm trying to think. I mean, immigration law can be fairly complicated sometimes with criminal law too. And that's where I think we have gotten into this, because I can't really remember the circumstances in a way that I can describe them. But and it might have been the other way around. It might have been that the criminal practitioner had no idea what the immigration implications were for criminal records. But anyway, you can see how it just gets all kind of mixed up here. So after 2002, this rule was approved. It's currently the rule in 45 jurisdictions. People seem to be making it work. It's not the subject of a lot of disciplinary cases or grievances. We still get the odd grievance about lawyers doing the kinds of things I described before. Serving as a front for somebody who's not a lawyer or a disbarred lawyer, just letting them run the office, and I'll just sign the pleadings because I don't feel like paying attention, that kind of thing, or opposing counsel sometimes complaining when their client is feeling that gets a letter from somebody who is not licensed in the jurisdiction. But one of the things that this whole change did is make people think about other ways that were easy ways to open up practice to lawyers not licensed in the jurisdiction who might need to practice there for one reason or another. And so in keeping with my chickens crossing the road theory here, we've got other paths to admission. Most jurisdictions allow some sort of reciprocity, or admission on motion, is what you guys call it. And in my jurisdiction, if you have a license from a jurisdiction that gives a Georgia lawyer admission on motion, you will give lawyers from your jurisdiction admission on motion. So it varies in how different places implement it. But for us, admission on motion, I think you have to take a lawyer's exam, but it's nothing like the bar exam. Folks are quite able to pass it. And we let a lot of people in that way, but they become regular members of the state bar. In-house counsel exceptions are in 31 states are just like that model rule that I just read to you. Military spouse temporary practice is something that a group of military spouses who move around because they are married to people in the service who move every 3 or 4 years, 2 or 4 years, created an organization, the Military Spouse JP Network or something like that, and really came to the American Bar Association, visited everybody in the world they could think of to visit to try to get the rules changed so that they didn't have to take a new bar exam every time they moved. And most jurisdictions have come up with a way to accommodate temporary practice, because it is not permanent duration, it's for 3 or 4 years, for somebody who's married to a U.S. service person, so that they can engage in practice in a the jurisdiction where their spouse is stationed. And that one, you see wide variations in how that's from confined to doing certain kinds of things, you can't do other things like go to court, to things that are almost as burdensome as the bar exam. So that's sort of a mixed bag, and not really, there is a model rule, but there's lots of variation in how states handle it. For legal consultants, we've also always had in Georgia, I say always for the last 30 years, we've had in Georgia, where if you are a lawyer in a foreign jurisdiction and you want to come to our state and rely only on the law of your home, you may do that. And most people see that as a positive thing. You supposedly are confident to find out the law of the jurisdiction where you're from. And so come on and to do that, but you can't talk about Georgia law at all. 15 states have exceptions for pro bono work, and those also vary widely. My state has one that says if you were licensed for something, you move to Georgia, and you want to do pro bono work, you can do it under one of these authorized entities without a license. And I can't remember if it is confined in terms of time, if you have to ultimately sit with the market, it would not surprise me. I think that is the case. You don't get to practice that way forever. But we'll let you come on in and like right away with your bar results. You can do things under that rule. Now this is a slide from another presentation that I did where the regulator from Colorado started talking about all the ways that they allow lawyers in. And it's a longer list even than mine. It includes UBE score transfer, and this unified bar, whatever it is, bar examination, that now I think 40, no it's not 40, it's more than half, I think, of the states, everybody knows, shout it out, but I think it is more than half of the states now use the UBE, which is a uniform bar exam. It's the same in every jurisdiction. And so it kind of does away with some of these claims that you've got to have specialized training in the law of Georgia in order to be competent to practice law here. But you can transfer your score on that exam and get admitted without having to take it over again or a whole separate bar exam in Colorado. They've got legal consultants, judge advocate certification for people in the military spouse thing, law professor certification. Now, we were talking last night, and I said I'm always surprised when law professors in my jurisdiction are not members of my state bar. And we had judges for a long time who thought that they didn't necessarily have to be arguing with the members of the state bar. But if that definition of the practice of law means anything, then judges are opining on what the law is. So surely, you finally should be advisory, they could verify that yes, they did. But not so clear for law professors. And apparently in Colorado, to be certified and become a member of the bar there if you are a professor of law. Pro bono counsel, temporary practice is covered under 5.5. Temporary practice by a foreign lawyer is covered under 5.5. Pro IPJ, and then practice pending admission is also popular now. And we do have that in Georgia. Practice pending admission really is a pandemic thing where it was going to take people a while to take the bar. Some people didn't want to physically go in and take the bar because of the pandemic. And so we didn't want to keep people from being able to earn a living. So we created this rule that allowed them to practice until the next bar exam was available. So a lot of jurisdictions have rules like that. Still, there are all these unanswered questions, the different interpretations of the temporary language in the rule, what these words mean, broad and vague statutes on unlicensed practice. Some do refer to geography, and I think most of them talk about where you physically are. But some actually refer to the continent of advice. So that if I'm sitting in Georgia and I'm talking about California law, like the beer bar case, am I engaged in the unlicensed practice of law in California? I'm not in California, but some jurisdictions interpret things. And so, the biggest hurdle, if you're expecting you to take a bar exam for every jurisdiction where your practice touches, that's time consuming, that costs money, you've got dues to pay if you become a member of every bar where you want your practice to touch. You've got different CLE requirements. You've got the possibility of discipline if you get it wrong. And then, some jurisdictions don't do reciprocity. I think the other thing for me that I have not particularly thought about with all of this was the fact that pro IPJ admission is restricted in a lot of jurisdictions. So if you've been admitted in Florida 3 times in 12 months, they aren't going to let you come back. They're going to say take the bar exam. And, for people who live on the border or whatever, that so then, the real motive for pushing us forward was the pandemic. All these issues and sort of sloppy decision-making that we were doing on a case-by-case basis about whether something was UPL and whether it wasn't changed when the pandemic hit. And even Florida, who I love to pick on, even Florida had to change its rule. And to Florida's credit, Florida was among the first jurisdictions to really decide to change its rule. And what they did is say, okay, we know you all you Georgia lawyers have details down here, and we know you're practicing from there. So, fine. But don't advertise that you can take Florida clients. Don't hang out a shingle and put your name on the door as though you are authorized to practice here. The words they use are invisible to the public. You can come down here and you can practice law in your own jurisdiction if you are invisible to the public. And that was actually a huge step forward for Florida because, as I said, they're the ones who were like, yeah, we know everybody wants to come here, so we are not going to make it easy. But really, after Florida's opinion, the APA actually was working on it, but it came out a couple months later. This opinion on lawyers working remotely, it's Formal Opinion 495 from the APA Standing Committee on Ethics. And they just say that you can practice while physically located somewhere where you're not licensed. You practice in your home jurisdiction law. It's something that I would have said, of course you can, but for all this confusion that people have about this stuff. And but for the fact that every now and then you get a grievance where somebody actually been hurt by it and you have to do some of it. So, conditions on being able to practice remotely. You can't do that if the law of the jurisdiction where you're practicing says you can't. So if your UPL statute is written in a way that includes whatever it is that you're doing, you can't do it. And for the most part, I think jurisdictions aren't going to count that a lawyer is engaged in UPL for being a lawyer, just do a regular lawyer. You can't hold yourself out. You can't advertise for business. You can't actually provide legal services for matters in the local jurisdiction. Okay, so yeah, you can't just take Florida clients, whether you've advertised to them or not. And you can't, this one was bizarre to me, and it's in a footnote in this opinion, you can't publish local contact information, like your office address, on communication that you have with clients. I feel like that's, we ought to be saying the opposite of that, because the main problem with all these things about misleading lawyers is people don't know where the lawyer is. And okay, I'm in Florida, but I'm not licensed here. This is saying that if you say, send me a letter at my Florida beach house, then you need to include a disclaimer or something on that, to just say, for mail delivery only, I'm not licensed, some affirmative disclosure that the fact that you have this address doesn't mean you're licensed there. And another thing that to me was just kind of ridiculous is nobody has a phone number that's where they are anywhere. It's like the phone number you got when you were in high school. I lived in Nevada in high school. And, I had a 702 phone number for Akron. And people don't necessarily associate this with where you actually are. So I think that they go a little far on that. But that opinion is good guidance for what you can, what you shouldn't, all that stuff with this group. Now, finally, we're getting to, I was supposed to be talking about 50 minutes ago, but Rule 5.5 and then the proposal to change it. So in April 2022, that Association of Professional Responsibility Lawyers recommended additional amendments to 5.5. And they just said, look, the main thing here is that A, it's going on already. People are practicing all over the place because they need to, their clients want them to. And there's no evidence of harm from them. People aren't being hurt by the fact that the Georgia lawyer is giving them advice about California law. People aren't being hurt by the fact that the Georgia lawyer comes to California to help do whatever it is that the client needs to do. So they made arguments based on access to legal services, choice of counsel. You ought to be able to pick your lawyer without regard to where that lawyer's license is. This whole virtual thing means that we can all practice from anywhere. And so maybe we should all practice from anywhere. This uniform bar exam thing means that we're all taking the same test. And so any excuse that you have about not being able to practice in a different jurisdiction because I haven't been trained in the law of the jurisdiction is less persuasive because we all took the same test. And there's no telling what any of us knows about the law in any particular jurisdiction. But the point is we're presumed to know it. We're supposed to be able to figure it out in a way that means that we become compliant. Regulatory burdens associated with reciprocity, I'll talk about in a minute, but that whole process is bulky and time consuming. So let's just not do it as the argument here. And then just the whole historical context. This protection of the public and ensuring confidence and ensuring ethical behavior is what we're about, then why does that need this geographic difference in where you practice that you just don't need that? And the different ways that we license all those other folks I talked about a couple of slides ago, nobody's really being harmed by that, so let's open things up even more. So April proposed changes to Rule 5.5 that just said, if you, I'm sorry the slide is so dense, but I'm not even going to spend a lot of time on it. It just says if you are admitted to practice in any U.S. jurisdiction, not disbarred or suspended from practice in any U.S. jurisdiction, you can provide legal services in this jurisdiction. And there are a couple of other provisions in their proposal. You have to be admitted in the jurisdiction to advertise. So if you're admitted in Georgia but want to practice in Ohio, you cannot advertise to the public that you are taking cases in Ohio. And that's clearly just to protect the lawyers in the home jurisdiction. You also have to disclose where you are admitted to clients and comply with the rules, the choice of law rules, and not assist anybody in the unlicensed practice. So the Association of Professional Responsibility Lawyers sent their proposal to the American Bar Association Standing Committee on Ethics because that committee is the only group that's going to suggest changes to law rules of professional. They have to get through the ADA. So the Standing Committee on Ethics is the group that suggests those changes to the ADA's House of Delegates. So April had to send its proposal to the ADA and say, please, ADA, consider this because we think the time is right. So the ADA is still in the process of considering whether to amend 5.5, and they welcome your comments. But here is what their current draft says. It's the same thing. If you're authorized and admitted by any U.S. jurisdiction, not disbarred or suspended, you may provide legal services subject to the other provisions of this rule. You can't practice law in a jurisdiction in violation of that jurisdiction's rules. You can't assist somebody. Really is the current language of 5.5. Then it imposes some conditions disclosing in writing to the client or prospective client the jurisdictions where you hold a license. That you're not, you have to affirmatively say, I am not licensed in this jurisdiction. You have to comply with each admission whenever that becomes available. Let's see. And you don't have to do any of that if you fall within one of those exceptions that allows ongoing practice anyway, like an in-house counsel situation or a federal exemption kind of situation. There are comments that the ADA has included, and I will get those to you all. I'm sorry I did not even attach them to the paper that I sent, because the draft is out there, and it is right, like I said, for comment now, and I think it's helpful for as many people as are concerned about it to comment on it. They really need to hear from a variety of folks. We had open hearings about the proposal at the American Bar Association meetings, the annual meeting well, actually, it was the bigger meeting in New Orleans. I'm not sure if they had it annual, but they will be holding more hearings and are always welcome, always open to written comments, if there's anything that you would like to say. But with my regulator hat on, I have to say I have mixed feelings about this, but I mostly support it. My client, the State Bar of Georgia, is horrified by that, by the way. And I think a lot of the objections, in fact, I told him I was going to take a vacation day today just to not cause any problems at all. But the concerns seem self-centered. The concerns seem to be more concerns about lawyers and us making money and sort of keeping the monopoly than they do about the public and any real concern about protecting the public. Yeah, I mean, the lawyers in particularly the rural parts of Georgia just see this as opening the floodgates, all those Florida lawyers coming up and taking all their business. And, you know, I can't imagine, I don't know. But the other way, one other way to look at that is as an access to justice issue. And that's one of the ways that the groups that are pushing this proposal are casting it. It's like, okay, Georgia, you're worried about us taking your business, but we just did a report where we've got 12 counties in Georgia that don't have any lawyers at all, 0 lawyers. And the people in those communities really suffer for trying to get affordable legal services. And wouldn't this help them? Wouldn't it help the poor people in Georgia otherwise who can't get lawyers, might drive prices down? And those are the things that we're worried about as lawyers. Other considerations for regulators. I don't have to worry about those Florida lawyers the way my job is cast right now. If you send me agreements about a Florida lawyer, I can send it to Florida and say, do something about your guy who's stolen some money. But under this proposal, who would regulate the folks who came into Georgia and harmed Georgia? If it all happened in my state, wouldn't I be expected to take a lead on investigating and maybe prosecuting? And how would I do that? Where's the resources coming from? You know, where's the money coming from to add staff if that's necessary, that kind of thing. Same thing with IOLTA. I don't know if you all are an IOLTA state, but you are, because actually the client security fund probably depends on IOLTA funds. So lawyers with Georgia trust accounts, we get the money in IOLTA, we use it to fund our client security funds, we do other charitable works. Where does the IOLTA funding come from if we're all licensed to practice anywhere? Same thing with client protection funds. If a Florida lawyer comes in and harms everybody, does my client security fund have to pay for that harm? Do I get to look at the home jurisdiction and say, you guys ought to pay? Whose CLE do you have to do? I know California has CLE requirements that we in Georgia just find crazy with all these sort of subsets of things that you have to get trained in. And we've just got 11 hours a year kind of a requirement. Do I have to comply with their rules of my practicing in their jurisdiction? Choice of law rules, I think, you know, we talk about the predominant effect of conduct and where that is as a choice of law issue. I don't think that one would be that hard to figure out. But, you know, who prosecutes? Do I have to prosecute? Does Florida prosecute? How do we do this? And then I've had malpractice insurance express concerns that I don't fully understand about whether this would make the cost of malpractice insurance greater. So as far as what's next, the ADA is still considering, they will have more discussion within the Standing Committee on Ethics. That committee will create a final proposal. It's looking like this thing that I just showed you, the interim proposal, hasn't changed in the year or so that they've been talking about this. So that may be the final proposal. For any change to the model rules, the ADA's House of Delegates has to approve. And the House of Delegates is 550 lawyers from all the U.S. jurisdictions who are representatives, they're all there as representatives of somebody, either state or local bars, ADA sections, divisions, other national organizations of lawyers. And I predict that this will be quite controversial. In fact, it may never pass the ADA House of Delegates. But the word is that the committee's going to try to get something done and perhaps present it at the annual meeting in August. So we will see what happens. If it does somehow get approved, I think it's still got a rocky road because, as I said at the outset, states have to approve it before it's effective in their state. And who will? It's like the first state that approves it is going to be flooded with lawyers from all over the country saying, I want to practice there. You know, so it's going to be interesting to see what happens if it is approved. If only a few states approve it, what's going to happen? If the ADA doesn't act, the only path forward that we can see for the whole proposal is something like what the military spouses did. They went straight to the Conference of Chief Justices. the ones who enact these rules, and said, we've got this good idea, we can't get anybody else to agree to do it, what do you think? And the Conference of Chief Justices voted to support. So it's the kind of thing the courts could do on their own. So, I mean, that's kind of where we are. And I'm going to leave it there, just ask if you have comments or questions, if they think it's a horrible idea, why are we talking about it, or if they think it's kind of inevitable and let's just do it like that. I'm kind of curious. Does anybody have anything? Thoughts, questions? Yeah.
One of the problems that we have, you can address it a little bit in our jurisdiction with the choice of law, is we had lawyers who are admitted, say, in another state, they only, let's say they only do bankruptcy. That was our case. But of course, just like you said, clients come in the door, and their bankruptcy is affecting their family law issues, real estate, whatever it may be, that requires some knowledge of local law or Ohio law. And so we had that situation. We prosecuted the case, and our court said, well, yeah, we have this choice of law provision, which on paper allows you to prosecute a lawyer for violating our rules, even though they're not licensed. But the court dismissed the case saying, how can we prosecute a lawyer when they've never taken an oath to abide by our rules? And so ever since then, how many years ago that was, we're just like, we're out. Because we have a precedent that we can't bring these cases. And that leaves us with the UPL prosecution, and of course our system is a lot different. So it doesn't have as much teeth. It's a longer process, and it's one of those things that we said that we really want to spend our resources doing it. So I kind of feel like the deck is stacked a little bit, like for change. I mean, even if you get through that case, we have a rule that says we can do it.
We have this similar situation in Georgia, and it really took the wind out of us in terms of any desire to try to prosecute anything like that. It's like, no, we don't hold this person's license. I mean, their rationale is, we don't hold his license. I mean, what do you want us to do to him? It's like, all we asked for was a reprimand, which you could have done just as easily in the text of his order. But, yeah, I agree that is frustrating. I think enforcement of out-of-state lawyers who really do something that's harmful, it's going to always be spotted.
And then when you send it to the other jurisdiction, they're like, well, nobody actually got hurt.
I protect Georgians only.
So it just seems to me, because I'm kind of with you, I'm feeling like this, the whole adversity of this comes down to money. And so that doesn't make me feel good. I do think that there's some relaxation of the rules is in order, but it does seem like it's going to be so many obstacles.
It is. It's not going to be easy. And there's so many things you have to think through. And money's a big part of it. We're a mandatory bar state, right? And so you must pay your dues to us. You must do all the discipline out of the bar organization. And if this happens, how do you even structure it? And the change is just too fast to think about, I think. So it's been easy to ignore all these years, but we'll see.
Doesn't the existing situation with very large law firms already do what you're saying, because they'll have a list of people from various states, committed practice in Florida, committed practice in Ohio. It's naive to believe that they don't talk to each other, they don't give advice to each other, and their clients don't talk to each other.
Well,
so doesn't this really sort of two levels? The very big law firms are doing this now, and the question to make it fair is without other people.
That is a good way to look at it. I will tell you, we've got our court would not amend Rule 1.2 is the one that talks about not counseling compliant communication conduct that might be criminal or fraudulent. And our legislature, they passed a rule allowing growth and sale of cannabis within the state on some, with a very structured program that needs lawyers to interpret it. And so, since cannabis is still a Schedule whatever drug under federal law, we had to interpret that it was technically a violation of law for lawyers to give advice about this new statute. So we go to the court very naively and just say, surely, people are going to need lawyers to interpret this new statute, and surely you want to help us fix 1.2 so that they can do that, or do an advisory opinion that says, we don't mean the new cannabis business. And our court said, no, we are not going to make it easy for lawyers to give advice about something that's still a crime under federal law. So the Georgia lawyers in the big firms got, their Colorado partners or, somebody in the jurisdiction that authorizes this and that did make an accommodation to sign off on everything. But it's the same firms and it's the same people doing the work. They just got somebody in the DC office to sign off on it. So I recognize that happens. I don't know what to do with that. Yes.
Yeah, I like the driver's license analogy because, technically if you're licensed to drive in Ohio,
Hit your
you
little
can drive.
microphone button thing, I can't hear something you're saying.
Yeah, I like the driver's license analogy because it makes sense that if I'm licensed to drive in the state of Ohio, I can go drive in Pennsylvania, New York, Florida, wherever. But then the kind of competing analogy, I do love throwing traffic for. So for Ohio, who goes to Pennsylvania and they wreck the car and get somebody, they can be prosecuted because I guess the thought is by driving out there on the road, you're going to have to violate laws. But then, you got the same analogy that, not saying where it comes here is not licensed, not sworn to practice in Ohio, I'm this one. So I like the analogy of closing abroad than the punishment section.
Yeah, it's different. It's the same thing. You guys have been wonderful. I appreciate you showing